On tether for 4 months. I showed up.
You want to keep talking? You want me to change it back?
No, sir. I apologize. I'm not trying
I mean, I gave you a break because with all that stuff, I shouldn't do it, but I can't give you a PR.
I understand.
All right, I'm done. Thank you.
I'm not trying to talk back.
No,
Your Honor, I'm sorry.
he showed up every time because when you show up every time, you get warned. That's how he got 3. What? No, I'm not doing anymore. Oh, what do you mean?
I gotta go.
Everything is going just fine. I see ghosts. I didn't hear you.
Okay.
This is Chad Jones. There remains 5 matters.
And Assistant Public Defender Nicholas Fukovich on behalf of Mr. Chad Jones in all matters.
Jones, can you state your name again for me, sir?
Chad Jones.
Thank you.
Yes, Your Honor, at the time, we'll be setting all his matters for preliminary exam. To my knowledge, all discovery is complete.
All right. Yeah. Oh. All right. People have their witnesses available. Date, what date? People have their witnesses available August. It can't be August 1. And normally we'd be on the 30th. It's not going to be August 11th.
We'll try for that date, Your Honor.
Preliminary examination in person, August 11th, 2026, 9 a.m. But we've got to transport him. What facility are you in, sir?
STF, St. Louis.
We're going to have to give more time than that.
Your Honor, I forgot he was in the state.
Set it for August 18th, 2026, 9 a.m. before judge. For me on the 18th. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. Jones.
Thank you.
Court does call the case, People versus James Johnson. 2 cases.
Good morning, Your Honor. May it please court Lowell Friedman, P5625. Your Honor, I appear on behalf of Mr. Johnson for one of his 2 cases. Specifically, that's case number 26FB 1411-FY.
Chelsea Virgils with and on behalf of James Johnson on the other case. Please state your name.
James Johnson. Thank you.
Your Honor, as to the first case, I'm in receipt of discovery as of last evening, but I haven't had a chance to review it, make sure it's comprehensive, nor have I had a chance to provide it to my client. My client understands his right to have the 21 days probable cause examination, wishes to waive that to return back to Your Honor. I looked at my calendar, Judge. There's only one Thursday that I have coming up that I'm triple booked, and that would be the 13th of August. Any other Thursday would be.
Asking for an adjournment.
Yes, please.
Do you want to have your cases together and have the preliminary exam for my case the same day as work, or do you want to set basic
Public Defender Office.
for the controlled substance? I would ask to adjourn as well to keep along with his case.
The next probable cause conference will be adjourned in both matters to August 20th, 2026, 9 a.m.
Thank you, Your Honor.
On continued.
Thank you very much, Your Honor. Have a good morning. So.
Court does call the case of People versus Rashad Barron. Excuse me.
I don't know. Good morning, Your Honor. Marcia Patron, on behalf of Mr. Bearden, who's approaching. Mr. Bearden, can you please state your name for the court?
Rashad Beard. Thank you.
Your Honor, if I may briefly, we are requesting to go to a preliminary exam at this time. I've spoken to Madam Prosecutor in this case. The pieces I'm missing is some media that she says should be get today, but in reviewing the police report, it's actually going to be eyewitness testimony. There is no video that relates to the crime of this. Therefore, I'm not sure how helpful.
I don't know what all that means.
Discovery is not complete, Your Honor. The media that I'm looking for isn't relevant to its eyewitness testimony would be an exam regarding the crime.
And Your Honor, I believe Ms. Bridger was appointed yesterday. That agent was sent to the public defender's office, so it should get over to Ms. Bridger before it's fully worked.
And also, it's Mr. Bearden, I was informed that there's a parole hold, and this is the only thing that's holding him, Your Honor. So we'd ask to go to exam as quickly as possible. Well,
Hey, Your Honor, can I say something? I don't know if it's wise for you to do that, but if you want to say something, you can go ahead. I was already going to court for this when I was just free in the world. I had a Zoom court date. I don't know why they ain't uplift the warrant for me, but I was already going to court for this in the world. I'm on a tether. I got a job. It ain't like I'm running from this case or nothing.
you make that argument because agent body court can't look at.
And yeah, I have this case being right on 7/19, and he does have a whole time use the Bob and I for violating school.
Got it. Okay.
Preliminary examination in person will be set for August 11th. Will people have their witnesses available that day?
In because of the pool.
August 11th, 2026, 9 a.m. Judge Barr.
That's argument.
On
Thank you, Your Honor.
here.
Yes, this is a parole hold.
Court calls case People versus Kenyatta Johnson.
Yes, call this for-
Morning, Your Honor. Christina Saxon. Judge Johnson. Excuse me.
State your name.
Kenyatta Johnson.
All right, what are we doing?
Your Honor, we're asking for an adjournment. Prosecution is still waiting on delivery of discovery that hopefully will be here within next week, though.
Preliminary examination will be adjourned to August 20th, 2026, 9 a.m. Bond continued.
I'm sorry, Your Honor, I didn't hear the date.
August 20th,
20th?
0.
Your Honor, I will not be in
I'm sorry?
I will not be in the country on the 20th.
Won't be in the country? Good. Okay. You know, every time I have to work around like your schedule, you just are jetting around the world. So what date will you be here on a Thursday? Hold on, Miss Johnson, we'll get it together.
The following Thursday.
The following Thursday?
All right, let's make it August 27th, 2026, 9 a.m.
It'll be my last in 4 years.
That'll be your last vacation?
4 years.
I don't know why. I did just say it out loud. All right, thank you.
Thanks.
And continue. Thank you, Ms. Johnson.
Thank you.
Court does call the case People versus Phoenix Forms.
Asphalt to people.
Good morning, Tina Saxon for Phoenix Forms.
Your name?
Phoenix Buenos.
You're requesting an adjournment of this?
Yes, Your Honor,
Want the bond violation also adjourned?
please. And if I may make a bond argument,
Okay. I will adjourn this to August 6th, 2026, 9 a.m. Yes, as to bond.
Your Honor, I'm asking for a release on house arrest for this matter. The reports I'm waiting on deal with mental health, and having him out would be much easier to address these matters than having him incarcerated. And with house arrest, I believe it would still meet the objectives of both the court and defense.
Response.
I apologize, Your Honor. I couldn't hear everything that Ms. Saxon said. However, it is my understanding the defendant on this case was originally released on a home confinement tether. He violated his home confinement tether and then eventually was able to be re-released and now is up a week from today on a new case involving a stolen motor vehicle. So I do not believe he is a good candidate to be released.
Your Honor, if I just may remind the court that the violation when he was on house arrest was over an issue of his mother demanding that he leave. Once we explain that to the honorable court, that bond violation was released. And
But he's got a new case coming up.
yes, I just wanted to say that he didn't just wantonly violate that bond while he was on house arrest. He was compliant other than that incident that we justified.
Motion for bond reduction tonight.
Thank you, Your Honor.
Thank you. Court does call the case People versus Daniel Polgar.
Albert, on behalf of Mr. Polgar, who's approaching the podium, will be standing to my right.
Your name?
Daniel Polgar.
You're waiving.
Yes, Judge.
Sir, you're waiving your right to a preliminary examination?
Yes, Judge.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Judge.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes, Judge.
People also waive their right. Preliminary examination have been waived. Defendants bound over to circuit court on both counts.
And Your Honor, there is an offer, if I may place it on the record.
Go ahead.
Your Honor, so the people at this, in exchange for the waiver, the people are offering to plead to HIDA at circuit court as charged, no upfront jail, three years probation, and no early discharge.
Both counts?
Yes, Judge. It's my understanding.
It's not a conditional waiver, though. Since something changes upstairs, we're going to make that preliminary signature.
Understood?
Understood.
As to the arraignment,
Stand mute, waive formal reading.
defendant have a waive from a reading standing mute. Court will enter not guilty plea to both charges. Pretrial will be set for
September 22nd at 1:30 with Judge Cummings.
September 22nd, 2026, 1:30. Okay. Bond will continue.
Judge. Yeah, Judge.
Court does call the case People versus Tommy Butler.
Ashley Feltus for the people.
Morning, Your Honor. Sam Bernstein, Whitson, on behalf of Mr. Butler. Butler, could you please state your name for the court?
Tommy Butler.
Thank you.
We're asking the court to please set this for preliminary examination. Discovery is complete.
Right, it's just the only thing holding it.
This remote fell and one of the batteries fell out. It was like,
Thank you. People have their witnesses available the 4th. It's 1 week out. We're
No, Your Honor.
not. Okay, the 11th,
Charge is not available on that date.
the 11th,
No, Your Honor, you can be available the following week.
the 18th.
Yes, Your Honor.
This is the only thing holding him.
I would ask the court to please have it sooner than the 18th. I understand there's a lot of availability from the OIC, but that's 3 weeks from.
Joe, I see the only witness in the case.
No, Your Honor, we can shoot for this date.
There'll be other witnesses. They may be continued, but I can at least start his preliminary exam.
I would hope so, Your Honor. Yes.
All right, so what I'm gonna do is I'm gonna set it for August 4th, 2026 at 9 a.m. before Judge Perry.
Thank you, Your Honor.
Fine, continue. Thank you. Court calls case People versus Sugat Hampton.
Ashley Feltus for the people.
Chelsea Rickmills with and on behalf of Suzette Hampton, please state your name.
Suzette Hampton.
Your Honor, we are asking for an adjournment in this case for some additional media discovery.
For media discovery.
Yes, Your Honor.
No objection. Probable cause conference will be adjourned August 13th, 2020. Bond continues.
Your Honor, may I address bond briefly? Ms. Hampton would,
No.
She is, Your Honor. It's a
Oh.
condition of her release to not leave the state of Michigan. She just informed me that she needs to drop her granddaughter off in Ohio tomorrow morning. And
Purpose?
unfortunately,
I don't know why people go to Ohio. Go ahead.
sometimes we have to, Your Honor. I believe it would be a brief trip just for the day. Where specifically are you going?
I'm going to Wilberforce in
Where?
Ohio. Wilberforce College in Ohio and Zeke, Ohio.
Dropping
My last granddaughter off
you're dropping your last granddaughter off
that I raised.
for us.
Yes, sir.
Start
Tomorrow
school.
morning. Yes, to start college.
I don't even know how I stand in the way of that.
I appreciate it so much.
When are you taking her down?
We'll leave it in the morning at 5:30 a.m.
Tomorrow morning.
Yes, sir.
So if I said no, what would happen?
I would have to find transportation for her to go to college.
Don't even. I don't need. Is there any objection from the?
No.
I'll indicate that defendant may travel to Ohio. What dates do you plan? You're going tomorrow, so that's the 20th.
I'm returning back tomorrow.
Just one day?
Yes, sir. Drop her off, decorate a dorm and all of that.
Come back the same day?
Yes, sir.
You don't want to be in Ohio for too long, right?
No.
Wow. Oh, Chelsea. Stole my line. All right. Yes, ma'am. You may travel to Ohio on July 29th,
Thank you so much.
2026.
I appreciate it.
All right. Not a problem whatsoever. And congratulations to your granddaughter.
Thank you.
Your Honor.
Court does call the case. People versus Kevin Sherrari Lowry.
Oh, no, I'm sorry.
No, he's here. No.
Good morning, Your Honor. Bernstein with and on behalf of Mr. Shenovar Lowry.
Your name?
Kevin Williams, Shenovar, Lowry Jr.
Thank you.
Your Honor, I'm hoping for an adjournment. I'm hoping to work on a resolution before we get to the exam stage.
All right. 13th meeting.
Yes, Your Honor.
Probable cause conference will be adjourned August 13th, 2025. Can you come see me? Bond can.
Your Honor.
Court calls case People versus Warren Abbott.
Can I get a muted?
Have developments with people.
Good morning, Your Honor. Karma Dadush on behalf of Mr. Abbott. Mr. Abbott, can you please state your name for the record?
Warren Abbott.
Thank you.
All right, go ahead.
Your Honor, we have received the competency report that was sent by the Forensic Center with regards to Mr. Abbott. We have no additional information to support or contest the finding and would ask the court to find him competent and ask to set the matter for PCC.
Any other evidence?
No, you will have no additional evidence. You all can the report and ask the court into that finding.
Court, after review of the report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist defense. Therefore, the defendant is deemed competent. Do you have an order, counsel, or no?
I will prepare
Why
one.
is that a surprise?
It should be.
Asked if you had an order.
It should be a surprise. I'll submit one. Yes, Your Honor.
Right. I'll set a probable cause conference for August 6th.
Can I address bond, Your Honor?
Man,
Is this a good time? Is Your Honor ready?
I'm ready always.
I was going to be asking for Mr. Abbott to be released on his own personal recognizance. He has been held for some time pending this competency. He does have a place to stay, his own place. He also has his adoptive mother that he can be, released, a good member in the community to help bring him back to court. He did have a job, but he is hoping to get a job when he gets out. So we'd be asking Your Honor for that. He is willing to put on any tether to ensure. I don't believe he's a flight risk, and for that reason, we'd ask for him to be released.
Yes, facts in this case are very disturbing. The defendant unlawfully entered the victim's home. She was asleep and woke up to find him standing over her / on top of her. She screamed, covered her mouth. There was a struggle. Camera did catch him nearby leaving her house or in the parking lot immediately adjacent, wearing certain distinctive clothing items. So the people were very concerned, and we did ask for a high cash bond when the case was initially brought, and we maintained that request.
Motion for bond reductions denied. Bond will continue.
Thanks, Your Honor. We'll come talk to you at the jail, Mr. Abbott, okay?
Court does call the case. Court calls the case. People versus Timothy Lacy.
People.
Good morning, Your Honor. Assistant Public Defender Davi Leba on behalf of Mr. Lacy.
Good morning, Your Honor. Timothy Lacy.
Thank you.
And Your Honor, we'd like to set this matter for preliminary examination. Please, discovery is complete.
Judge Garwood.
Thank you, Your Honor.
Bond continues. Court calls the case. People versus Floyd McMurray. And
People.
Gabriel, on behalf of Mr. McMurray, standing in and returning of record Bill Amadeo. Mr. McMurray, please take your name for the record.
Floyd L. McMurray Jr.
I thank you, Your Honor. Today's the date and time set for probable cause conference. Mr. Amadeo was just appointed, so we are asking for a brief adjournment.
probable cause conference will be adjourned to August 13, 2026, 9 a.m.
Thank you.
Thanks.
Thank you.
Oh, who's on there? Program. Just watch something. Okay. You could run it to me. Oh, sure. Court case of the people versus Travarilis Durham. 2 cases.
Kenneth Elvis for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Durham.
Your name?
Travarilis Durham.
All right.
Your Honor, we're asking the court to please set this for preliminary examination. Discovery is complete. And if I could address bond at the appropriate time.
People have their witnesses available the 4th.
You try for that date, Your Honor.
All right. Preliminary examination, both matters will be set August 4th, 2026, 9 a.m. before Judge Washington. As to bond.
As to bond, it's going to be very upfront with the court. Mr. Durham.
Thank you.
Yeah.
Go ahead.
I guess it'll sound slightly better for me than Ms. Feltus. Mr. Durham did fail to appear at a preliminary examination 3 years ago. We are here now. He is very sorry that he did not appear. He was a bit more unstable back then, and he has done a lot in his life since then to gain some security and stability. He has an apartment now.
3 years ago? I just wanted to make sure.
2023, Your Honor. Yeah.
Okay. All right. Go ahead.
But he has really worked hard in the interim. He has an apartment now. He's housed. He has rent due on August 5th. He has a 1-year-old son who is now with his mother while he's been incarcerated, but he's eager to get back with him. He has a job now with Miles and Sons Landscaping that he can return to if released. And I would suggest that all of his strides that he has made
into custody.
He was in a car that was pulled over by the police.
Oh.
It wasn't a new charge, at least, right? So the car was pulled over by the police and he was a passenger. And when they looked him up, they saw who he was.
And then he came into custody 3 years later.
And we're begging the court's consideration for any sort of bond reduction that may be possible.
Oh, yep. She popped right up. Go ahead.
For the court's making 2 cases. One is an armed robbery where bond can absolutely be properly denied and should be, in my opinion. I will let the court know that 3 years ago when the case was proceeding to preliminary examination, We had had good contact with the victim who was on their way to here when the bench warrant was issued for the defendant. So I do believe that bond should properly be denied.
Motion for bond reduction is denied. Bond will continue as denied. Thank you.
Yes. Thank you for your consideration, Your Honor.
Yeah.
I just put shoe bar.
Did you?
Yeah, I just. Court does call the case. People versus Aaliyah Benton.
Good morning, Your Honor. James Latfelski appearing on behalf of Aaliyah Benton Roach. If you can, please.
Aaliyah Benton.
Thank you.
Your Honor, we're asking for an adjournment. The holdup is there's a co-defendant who is in custody, I believe in Georgia, and he's in an Arkansas. He's in an extradition process, and we can't really do anything until he gets up here. So we're kind of at a standstill. But
That's correct statement. We're working on the extradition process for that codependent damage. His presence will be very hard to have a resolution in this case.
I'll adjourn it at this point to August 27, 2026, 9 a.m. We thank you, out where we are at that point.
Okay.
All right, bond will continue. Thank you.
Thank you. And just one comment, Ms. Bring, and I believe we have a stipulation to modify the no contact order with regard to Samir, the youngest child, because DHHS has been supervised parenting with my client and her other kids. And I believe we're in agreement that as long as it's supervised.
Thank you.
Your Honor, we are going to waive preliminary examination.
Right. Sir, is that correct?
Yeah.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing, but you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with two following.
We'll stand mute, Your Honor, waive formal reading of the charges.
Defendant have waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
August 10th at 1:30 with Judge Moon.
August 10th, you said?
Yes.
August 10th, 2026, 1:30, Judge Hamud.
Can I address bond, Your Honor?
Why not? Everybody else. Go ahead.
You remember he couldn't stop using and we had to get him someplace safe. He went in the hospital to detox and he was there for a week. As soon as he got out of the hospital, you had told him to report to the jail immediately, which he did on the 15th of July. And he reported right from the hospital to jail. He's been there ever since the 15th. I just got notice this morning that he is eligible for felony treatment court. They would like to do a screening and assessment as soon as possible. So I'm hoping that I can get him released back to his father's house and to get him continue in recovery. He's done everything that the court wanted him to do, obviously in a scram tether with testing requirements, but I think it's a really good what you did here to allow him to safely detox because he has seizures and he's been injured before from the seizures. So when he was in the hospital, he went through the seizure protocol and got through that. And he's been in the jail now since so I'm hoping that you allow him to go back home and we can get him into felony treatment court.
Your response to the people.
Yeah, I still have a lot of the concerns I had the last time. I just want to place on the record. This is an OWI third. The priors are from 2016 and 2024. In this case, the alleged offense is that he was operating under the influence of fentanyl, methamphetamine, and THC. He did have some very concerning initial positive tests. more concerning, maybe even so, is that he stopped showing up to community corrections, and then the warrants got issued and everything, and Mr. Shan just placed on the record happened. I'm very optimistic about felony treatment court for this defendant, but the concerns I have for bond right now are just the not showing up, kind of going up. I'm just worried about his ability to keep the public safe and how much the public safety does depend on that at this point, but I leave it in the court's discretion.
When is his assessment?
Courtney said as soon as tomorrow that
He may do that tomorrow.
yes.
Okay.
Now that I'm clean, I have full intention of showing up to community corrections. I just kind of.
You know what? Hey, young man, I'm not mad at you. Okay. I'm mad at the drug that you're hooked on.
I saw him yesterday. I said, I've known him for a long time. This is the best he's looked in a long time.
I remember when you were.
I'm on the MET program now, and I don't know, I'm giving it my best effort.
Yeah, no, I got you. So who would have his felony?
It would probably be Judge Carol Cookie, because she's doing most of the felony. This is a felony drunk driving. However, his drugs of choice are non-alcohol related.
Okay.
So it's meth and Xanax, methamphetamine. It's easier to list the drugs that he's not taking than it is the drugs that he is taking. So I think he'd be a perfect fit for Judge Cookie's felony treatment court. And I've already let Judge Hamoud's staff know that he's coming. Hopefully we'll have everything lined up for a smooth process and get him in treatment court as possible.
Okay. Here's what I'm going to do. And understand, I'm not doing this to punish you, young man. I'm worried about you. Okay. And I think you have full intentions of doing what I say, but I'm just worried about it. I'm going to deny the request for a change in bond at this time. However, I'm specifically placing on the order that I have no objection to his release after he's assessed by drug court.
Perfect.
All right.
Perfect. That's all I was. Thank you, Your Honor.
So at this time, his bond will continue. All right. Thank you. Good luck, Chief.
I'll let court know she'll probably be here.
Court calls the case People versus Michelle Schaffner.
Good morning, Your Honor. Christina Costantino appearing with and on behalf of Ms. Schaffner. Michelle, can you please unmute and state your name for the court?
Michelle Schaffner.
I need you to turn the camera on, please, ma'am.
Sorry, I'm at work.
Okay. I've seen people at work before. You're good. All right. What are we doing?
Your Honor, Ms. Schaffner's co-defendant was Kenyatta Johnson, whose case this court heard a little bit earlier this morning. That matter was adjourned to August 27th due to some outstanding discovery. It's my understanding that same outstanding discovery is missing in our case. So we would be asking for an adjournment of the PCC for that same reason.
Correct, Your Honor.
I'll adjourn the matter August 27th, 2026, 9 a.m. Bond continued. Thank you.
Thank you very much, Your Honor. Have a good rest of your day.
You do the same.
Thanks.
Pardon? Court does call the case People versus Raymond McCarthy.
People.
Alexander Hermanowski with and on behalf of Ramon McCarthy for the case ending in 5144.
And Kerma Dadush on behalf of Mr. McCarthy in the other matter. Can you please state your name for the record?
Andrew McCarthy. All right. Go ahead. What are we doing?
Your Honor, with regards to 5144, this matter being adjourned, requesting that it be adjourned as Mr. Drukas, who I'm standing in for, just was appointed on the matter yesterday. So we're asking both the bond violation and the PCC be adjourned.
And we were going to be asking for an adjournment on the 5146 matter. I believe there may be a potential case that may be getting authorized. So we'd ask for an adjournment on all the matters so we can resolve them globally together.
There's another case being authorized. Do we know anything about that?
There's another potential misdemeanor.
Oh, misdemeanor.
It may end up being a felony. I haven't had a chance to review it, Your Honor.
Okay. Are these the only things holding him, or is he held on something else?
I'm checking, Your Honor, but I believe they're the only things holding him.
And Mr. Jerkis just got into the case. I'll adjourn these matters to August 13th, 2026, 9 a.m.
These are the only things holding him here. There are 3 out-of-town holds.
Got it. Okay.
August 13th.
Yes. Thank you, sir.
Thank you, Your Honor.
Thanks. Court does call the case People versus Dontrell Smith.
Michael Gay, public defender on behalf of Your Honor.
I'm here.
Your Honor, this is the date and time for a competency review. I was unable to see Mr. Smith.
You were not true.
No, we were, and he was, we tried again this morning and he was not.
Yeah, he's in. Mr. Smith, can you state your name for me?
Dontrell Smith.
Thank you. All right. So why don't I do this then? I'll adjourn the competency hearing out. You'll be able to get down there by the 4th, or you need?
Yeah, yes, it's just,
I mean, not the 4th, but
based on the previous look, it may be better for me to arrange a Zoom meeting.
Okay. Competency hearing will be adjourned then to August 6th, 2026, 9.
Thank you.
Bond continue. Hi. Did you see it? You did? You didn't warn me. My cat does that and sneaks in front of me. Put a bell around it. Get a bell. Court calls the case Bill versus Borough Shelton.
Morning, Your Honor. Dan Garrett on behalf of Mr. Shelton. State your name, sir.
Borough Shelton.
Your Honor, we're asking for an exam day. Discovery is complete. Fortunately, the only day I can't do is the 11th.
You know what? He was free and available up to size.
Yeah,
And
true. Blame Roland.
people have their witnesses available the 18th. Preliminary examination in this matter will be set August 18th, 2026, 9 a.m. for Judge Moore. Bond can
take your arm.
Thank you. Court calls case People versus Michael McLean. 3 cases.
Good morning, Your Honor. Assistant Public Defender Alexis on behalf of Mr. McLean on cases in 5530 and 1395.
Good morning, Your Honor. Christina Saxon for Michael McLean on case 5221.
Your name?
Michael McLean.
Thank you.
Your Honor, with respect to my 2 cases, we're going to be requesting they be set for preliminary examination.
Same, Your Honor.
All right. Discovery is complete on all your matters?
My knowledge, Your
My
Honor.
knowledge.
Is this the only thing holding him? People have their witnesses available the 4th? All right. Preliminary examination in these matters will be set August 4th, 2026, 9 a.m. before Judge Perry.
And Your Honor, can I briefly address the matter of bond? I would just be asking that he be allowed to be released to treatment.
If you submit an, unless there's an objection.
Jack, he was
Of course you are.
filtering 2 new cases and that's now there before Your Honor. So I don't believe that at this time that's appropriate.
So I had previously released him to treatment on one of these
2 more cases while he was out. Did not go there.
and didn't go to treatment.
Did it. And then he picked up 2 more cases and came back to. So I don't object.
And Your Honor, if it might be a more appropriate time to make that request at preliminary examination, that's understood.
And certainly not appropriate today. I'm not going to sign that order.
Understood, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Douglas Hill. 2 cases.
That's Johnson people.
No, take your time.
Miller, P. 58 on behalf of Mr. Hill.
And Michael Gaddy, on behalf of Mr. Hill on 26 FB 1360.
Your Honor, if the court could pass the matter, I've been in
Why would I?
contact with Mr. Hill. He was on the number 4 bus and I expected him to be here by now. If we could just pass it 10.
I don't even know where the number 4. What number 4 bus?
The number 4 runs up and down Washington, Your Honor. I take it from this court when I go down to the circuit court.
Is that right? Okay. Fine, I'll pass it.
Thank you, Your Honor.
See, and I asked him and he couldn't even give me an answer. Did you see how he is? Watch him closely. Did you know the number 4? No? You guys are doing me no good. Court does call the case People versus Matthew Moy.
For the people.
Your name?
Name, sir?
Oh, Matthew Thomas Moy.
Good morning, Your Honor. Marcia Page on behalf of Mr. Moy. Your Honor, we have 2 asks today. First is to adjourn the PCC for obtain discovery and further plea negotiations. And the second ask is we would ask the court to entertain a bond reduction motion.
Go ahead.
Okay. My understanding that Mr. Moy has nothing else holding him. He has a current job at Kentucky Fried Chicken. He needs to get back to his job. He also has some apartment that he needs to make sure that the rent is paid. Currently, his bond is $1,000 cash surety. We'll be asking for a personal recognizance bond. This is resisting obstructing. It's my understanding that there was no injuries to the officer. It was basically a running from the police situation. So we'd ask for a PR bond, Your Honor.
Response.
And my understanding is that the defendant's been on probation in circuit court for carrying concealed weapon and possession of controlled substance for quite some time. There was violation of probation resolved in May 2026 when he had completed treatment. He also has an assault battery pending while he's on probation. In this case, was pulled over, asked if he could just walk away from the traffic stop, and the police officer told him no because he had active warrants. He then ran. So I have no faith that he will come back.
He explains to me that he will come back, Your Honor. Mr. Moy.
Matter of court.
Go ahead.
Your Honor, this incident was about 5 months ago.
I'm gonna ask you not to talk about the incident.
Okay,
So
I'm just okay. I won't discuss the incident. I was released so I could go to treatment. I've been keeping up with probation. I'm in the courthouse every week, Your Honor. And I've been keeping up with my appointments. The KFC that I work for is right across the street. I've been dealing with the court system for a while, Your Honor, and I understand that I have to take care of these things. I'm not going anywhere. It's not an
Why
apartment.
didn't you come back though?
Why did I come back?
Have all these warrants and then they pull you over. Could have dealt with it, but then you took off.
Oh, I didn't take off, Your Honor.
hold on.
The charges were just filed. I'm
gonna advise you at least.
Yeah, I would.
You not want to say anything.
Yeah, I was.
Bad. Celtics, you were gonna say something else.
I want to clarify. They got him. So he ran from the traffic stop and they were able to catch up with him and put handcuffs on him. I'm not sure why there was a delay in the case. But my understanding from the police report is at the time of the arrest, he had active warrants. And that was in February of this year. And since then, there was an assault and battery case in Ypsilanti, which has also been filed with an incident date from April of this year. And now we are here, both of those having happened since he's been on probation for the CCW case is my understanding.
I'll grant the motion, but I'm not gonna give him a PR. I'll make it a 10%
Thank you, Your Honor.
round.
Okay, thank you.
If I have to give you a date, we'll set his for PCC. PCC will be adjourned to August 6th.
I'm on tether for 4 months. I showed up.
You want to keep talking? You want me to change it back?
No, sir. I apologize. I'm not trying.
I mean, I gave you a break because with all that stuff, I shouldn't do it, but I can't give you a PR.
I understand.
All right, I'm done. Thank you.
I'm not trying to talk back. Beth. Hold up there.
You know,
Your Honor, I'm sorry.
showed up every time. Because when you show up every time, you get warrants. That's how we got 3. What? And no, I'm not doing anymore. Oh, what do you mean?
I gotta go.
Everything is going just fine. I see ghosts. I didn't hear you. Courthouse case, People versus Lawrence Ransom.
People.
Joy Gaines, Senior Assistant Public Defender representing Mr. Ransom. Your Honor, I have attempted to reach Mr. Ransom by phone.
Number 4 bus. Never mind.
My-
No, he's not. No, he's not. No. Go ahead. What were you gonna say?
I did attempt to reach him yesterday by phone. I believe his was one of the court dates that was changed. I was unable to reach him. He has been working with and meeting with the 34th District Court in an attempt to resolve this matter with him appearing in a specialty court in Wayne County. So I would ask for an adjournment to get him to court today, please, or a different day.
You're so nice when she asks that. But no. Bench warrant will issue for defendant's failure to appear, but I won't issue it until Friday.
What's the name, Your Honor? I'm sorry.
Thank you.
Pardon?
Mr. Ransom.
Your Honor, can you just break your name for?
On this one?
No, on a separate title.
Fine.
Thank you, Your Honor.
I've got to stand up because they're only like this tall.
Yeah, it's true.
Over the thing.
Oh.
Judge Slay.
August 13th, 2026, 1:30, Judge Slay.
Can I address bond briefly, Your Honor?
Sure.
I did have a chance to talk to Brad Smith and Diana Curry before today. He's been participating in the Dawn Farm Jail program. He has 5 weeks of sobriety as of yesterday. He's doing terrific. He has a place to go. His significant other is here. They've been together for 7 years. She's a professor at University of Michigan. She's got a safe place to go. I would be fine with a scram tether or a home confinement. We do have an application in for felony treatment court. He does need to be screened and assessed, and there's an issue as far as eligibility. But
Professor or the?
She is, yes. But I wanted to make sure you knew she's got a safe place to go. They have a home together, have had for 7 years. So he's got a safe place to go from here. There is an issue about eligibility, which I've talked to Ms. Feltus about, but they are willing to consider an application, and I would like to see if I can get him out of here. He does have an opportunity to get into Dawn Farm inpatient residential treatment, 90 days. We have talked to the Dawn Farm intake team, his family has, and he had an opportunity to get into the farm as well. So I'm just asking that he be released to even home confinement.
How much time does he have on the Dawn Farm in jail program?
How many weeks have you been going with in jail program?
3 weeks into that program right now.
3 weeks?
You're 3 weeks in?
Yes, right.
I think Your Honor recalls this case from the last time we were here, when he was found with so many different firearms and with the mask and all those concerning things. I still have all the same public safety concerns that people had before. The treatment, alcohol does definitely seem like it's at the root of this. But the people would ask that if the court is going to release him to the inpatient treatment, which I understand is going to be self-funded from his family or from himself, that he's put on the GPS and Instagram, both, so we can keep an eye on him. I'm very concerned with the large number of firearms, if he does get out for his treatment, that we're able to locate him. The other concern is, like Mr. Shand alluded to, whether or not he will ultimately be eligible for felony treatment court with these types of charges remains to be seen. But it does appear that that is what is necessary.
And we're fine with GPS tether and a scram tether, Your Honor. So that's not an issue. We do have pretty good relationships with felony treatment court, and we've been doing this for a while. So I'm hoping that the foundation of the issue, if you look at the video, is he was hammered and he was passed out beside his truck, and he has no memory of what happened. So I'm just hoping that if we address the foundational issues here, that the rest of this is going to be taken care of.
All right, what I will do is at this juncture, it's going to be another funny one. I'm going to deny your request. However, get me an order. You have to get it to me today. Releasing him to inpatient treatment on a GPS and scram tether.
Okay, perfect.
And those would need to be placed prior to his release from the jail.
Thank you, Your Honor.
All right. And so he'd be released on a PR with those conditions. All right.
To be revoked if he walks away.
Walk away.
I'll bring him back.
I know, and I know you will. And I know that, Mr. Shand. So I don't even worry about that. But walk away.
Not be for a while.
All right. All right. Okay. Thank you.
All right. Thank you, Your Honor.
You make sure that order gets to me today.
I will.
All right. Let's call the case of the people versus Benjamin Spike.
Yes, Your Honor.
Yeah.
Good morning, Your Honor. Assistant Public Defender Alexis serves on behalf of Mr. Spike. Mr. Spike, can you state your name for the judge?
Benjamin Paul Spike.
Thank you, sir.
Your Honor.
Your Honor, we'd be requesting an adjournment to continue discussions with the people.
It's just the only thing he's held on.
Yes, Your Honor, if I could briefly address bond.
That wasn't an end. Good.
Your Honor, we would be asking for a personal bond. Mr. Spike is eager to get back out to take care of some of his affairs. He has a friend he can stay with, an Adrian, and he does have his dad who provides support for him and transportation.
Why didn't he?
From court? Your Honor, I believe that might have just been an oversight on Mr. Spike.
Oh, okay. Probable cause conference will be adjourned to August 13, 2026, 9 a.m. Motion for bond reduction denied. Bond will continue.
Understood, Your Honor. Thank you.
Court calls case people versus Justin Thomas.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Thomas, who I believe is present via Zoom. Mr. Thomas, can you please state your name for the record?
Justin Thomas.
Got it.
And Your Honor, our AIM division is still working on a mitigation report with Mr. Thomas. We'd be requesting an adjournment for that purpose.
Adjourned August 13, 2026, 9 a.m.
Thank you, Your Honor.
Court calls case people versus Adina Self.
Alexander Hermanowski, I'm still here. Alexander Hermanowski with and on behalf, Kadena Self was standing on my right. Please state your name for the record.
Kadena Self.
Most I've seen Hermanowski in person. All right. What are you asking for?
Your Honor, at this time, we're asking for a brief adjournment. I was just appointed on this matter yesterday. I haven't had a chance to review the discovery.
And there may be additional discovery, however, not extensive, but a few calls.
A few calls. Okay. I'll adjourn it out to the 13th. How many calls are we talking about?
7 calls that so those calls are all under a minute. However, there's also the call log of the other 6 or incomplete calls that she attempted to the victim. So at this point, I'm also going to be asking that her text and phone privileges be revoked, given that she's on conditional bond out of 15 for a case with the same victim. The no contact order was placed on this and is still in place. And she's continuing to violate that court order.
If you've got anything you say, you can say it, but I'm going to do what I do.
Your Honor, you can just go ahead.
All right. I will grant the prosecutor's motion to revoke phone and texting privileges of this defendant while incarcerated. Her bond will continue. All right. Thank you.
I'm sorry, Your Honor, adjourned to what date?
What did I give? 13th.
Thank you, Your Honor.
You. Court calls case People versus Samantha Kane.
Question belts for the people.
Good morning, Your Honor. Roland Sizemore appearing with and on behalf of Coach approaching the lectern.
Your name, ma'am?
Samantha Kane.
Mr. Sizemore, it's good to see you, sir.
It's good to see you, Judge.
All right, what are we doing?
Well, we just got retained. We're asking the court for 3 or 4 weeks to get discovery and be prepped for the hearing.
Hearing no objection, 20th or 27th, which would you prefer?
How about the 20th?
All right, I'll bring matter to August 20th, 2026, 9 a.m. Bond will continue.
We do have one question about bond, Judge.
Why not? Everybody else then. Go ahead.
This is an R&O case. It's the only count charged. However, the police were responding to a call that she made that may or may not have involved a domestic incident. As such, there is a no contact order with her husband and a no go-to order for the residents, even though this isn't charged assault of crime and he's not a victim. He's present in court. They both would ask the court to remove those 2 conditions from her bond.
That's correct, Ron. That is my understanding of the conditions as well. Victim advocate Roddy did have a chance to speak with Mr. Kane and let him know that generally this court does like to hear from folks about that. So he's prepared to address the court. The court would like to hear from him.
Yes.
If you'd like us to approach, we're happy to do that as well.
Yeah, well, if you could approach,
Thank you.
do it that way. I don't. You say 10 years and 2 years.
No contact should be lifted.
Okay, you don't have any fear of her at all?
No, sir.
And what's her relation to you?
My wife,
How long you guys been married?
9,
You should be able to spit that out a lot quicker than that.
10 years, sir.
You know, I know what? I just say no because he couldn't get the number of years. Go ahead, I'll give you another shot.
Years and 2 weeks.
You say 10 years and 2 weeks.
He does.
So now he's got it back.
Mhm.
All right. Was there a no go to?
Yes, Your Honor.
Okay, on this one, thank you, sir. I'm going to grant the motion for modification of bond, given the nature of the charges and having heard. So I will get us back in there. I will delete no go to, and also I'm just going to delete the no contact. I'm not going to even.
Thank you, Your Honor.
Non-consensual contact. I'm just going to delete them.
Thank you.
Right? Thank you.
Do we wait here for an order or should we go down there for a bond order or will we not get a bond order?
Mark. Won't get one because it's him. Yeah. No, he won't get an order. No, you won't get a copy.
No order then?
Yeah, no order, but we'll be removing both of those provisions from lien.
Okay. Thank you, Your Honor.
All right. Thank you. Take care. Court calls case People versus JudgeSimpson.
That's just about this for the people.
No relation. Okay. Who's your attorney?
Oh. This is his picture.
I know. Is she in the room or is,
Everyone, I don't think.
because she'd be so small, we wouldn't see.
Sorry, Your Honor. Good morning, Your Honor. Marcia Creech on behalf of Mr. Simpson.
Your name, sir?
Derek Simpson.
Thank you.
We'll be asking the court to set this for exam. Discovery is complete.
People have their witnesses available. Is this the only thing holding him?
I believe so. There may be a misdemeanor issue, but I think this case is driving it.
Will people have their witnesses available the 4th?
Correct, that's Your Honor.
Preliminary examination will be set August 4th, 2000.
Court and the public defender's office. Although the people do not meet, there is any confidence will make its waiver before.
Good morning, Your Honor. Your Honor, we too do not believe that there is a conflict, but would waive any conflict in case there is any doubt.
Thank you. The court, for its part, also does not believe it's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Angelina Bonacera.
Ashley Beltis for the people.
Good morning, Your Honor. Assistant Public Defender Alexis Serpston on behalf of Ms. Bonacera. Can you please state your name for the judge?
Bonacera?
Your Honor, we'd just be requesting an adjournment so we can coordinate a visit with Ms. Bonacera.
Like ages.
I know. Good. How are you, Your Honor?
Doing okay. So go up here and then you ask for an adjournment. All right.
Heard that a lot this morning.
How much time did you need?
Your Honor, a few weeks.
My dates are all off here. You have 6 and a 13.
Correct.
Probable cause conference, we're gonna have to go to the 13th. She's in. Probable cause conference will be adjourned to August 13, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Go.
Thank you.
Court calls the cases of the people versus Chad Jones.
Ashley Beltis for the people in all matters.
All 6 cases. Oh,
Good morning, Your Honor. Alexander Hermanowski on behalf of Chad Jones, standing in for Ed Drukas on a case ending in 2196.
Mr. Lemo's on there.
we're all looking for Lebo.
Oh, what's up there? No, this is all terms.
You should close on these. Somebody go get him.
He is in both courtrooms. He did say he put his notes in the files. We're just gonna pull them up.
Okay. I'll wait.
So sorry. I just love him.
No, you're the only one that could get away with this. So, Mr. President, how are things going?
Fantastic.
All right.
Things couldn't be better.
Well. We're off to a rip-roaring start. Mr. Jones, can you state your name, please?
Chad Jones.
Thank you, sir.
Your Honor, in terms of a case ending in 2196, Mr. Jones is waiving his preliminary examination.
2196, he's waiving on now.
Yes, Your Honor.
Sorry. Mr. Jones, is that correct? You're waiving your right to a preliminary examination in that case?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
You'll also waive their right on that case.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Hermanowski. Waive formal.
Yes, Your Honor.
Stand.
Stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in that case will be set for
August 17th at 1:30 with Judge Hamoud.
August 17th, 2026, 1:30, Judge Hamoud.
Thank you, Your Honor.
Thank you.
Your Honor,
Bond will continue with that. Go ahead.
Your Honor, could we pass on this for just one moment, please?
I don't know how long MDOC is gonna wait.
I will not be long.
All right. Mr. Jones, I'm gonna pass your other matters and then get your call back up momentarily, okay, sir?
All right.
Court calls case People versus City Hall.
That's all people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Hall.
Yes,
State your name.
Sade Renee Hall.
All right. And what are we doing?
Your Honor, this is a time and date for a competency hearing. I did meet with Ms. Hall yesterday and went over the competency evaluation with her. We don't have any additions or corrections to that report.
We
don't have anything.
What's the date of your report?
I cannot hear people acting out right now, and they got the camera on me, and I'm looking at myself, and I look darker than what I appear. Like,
Okay.
this is messing with me.
Okay.
Put me as like I'm.
Just hold on a moment.
I mean, I'm very light skinned.
What was the finding on that?
I have July 17th with the finding of incompetent but restorable, I believe.
Yes, it says the possibility of restoration, Your Honor. It was, July 17th, we received that.
Okay, I see.
This is
All
messing
right.
with me. Look at
Court
my
will find that at this time is incompetent to stand trial, but restorable. Court will sign the order to that effect. I'll set a competency review hearing,
see, the color is just fading.
9th, 2026, 9 a.m.
Thank you, Your Honor. Thank you.
Thanks.
I can't hear. She's messing with the screen now.
Thank you. I'm sorry, ma'am.
Ash is messing with the screen. She put it on unmute.
Okay, we're all done. We'll see you
I
in
didn't hear what
October.
happened.
What happened? I made a finding based upon the report, and then I set a review hearing for October 29th. And we'll see you then.
9th, my birthday is on the 18th. I've been here since April 16th.
Okay. We'll see you then. Thank you.
Call is ready.
Court does call the case People versus Joseph Lovely.
Assistant Public Defender Zach Binu with and on behalf of Mr. Lovely, who approaches. Sir, can you please state your name?
Joseph Lovely.
Your Honor, we're requesting an adjournment. Mr. Lovely is waiting on a bed for treatment, so we are requesting adjournment for that purpose.
Is this the only thing holding him?
I believe so, yes.
All right. How much time did you want to give him?
3 weeks should be enough, Your Honor.
Public cause conference will be adjourned August 13th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court recalls the cases of the People versus.
One defendant wants another chance. Another hopes for treatment instead of jail. And one after another, people stand before the same judge asking for mercy. But throughout this courtroom session, the judge makes one thing clear. every request has to be earned, not simply asked for. The morning begins with routine scheduling hearings, but the tone quickly shifts as more serious cases reach the bench. One defendant is found incompetent to stand trial, but restorable, meaning treatment could eventually make them fit to continue the criminal case. Rather than pushing forward, the judge follows the evaluator's recommendation and schedules another review, emphasizing that the legal process must pause until the defendant is capable of participating in their own defense. Soon after, another defendant asks for release while waiting for a treatment bed. The defense explains that treatment is the only issue delaying the case, and the judge agrees to adjourn the hearing for several weeks, allowing time for placement while keeping the existing bond in place. One of the day's toughest moments comes during a bond hearing involving Warren Abbott. After a competency evaluation finds him fit to stand trial, the defense argues that he's no flight risk, has family support, and is willing to accept electronic monitoring if released. But prosecutors paint a much darker picture, describing allegations that Abbott unlawfully entered a woman's home while she slept and was later identified through surveillance footage. After hearing both sides, the judge wastes no time denying the request for bond reduction, ruling that public safety concerns outweigh the defense's arguments. Another emotional hearing centers on a defendant battling severe drug addiction. His attorney explains that he voluntarily entered the hospital to detox, has remained in custody ever since, and is now being considered for felony treatment court. The prosecutor acknowledges the value of treatment, but reminds the court of repeated failures to appear and concerns about public safety. The judge delivers a compassionate response, telling the defendant, "I'm not mad at you. I'm mad at the drug that you're hooked on." Even so, the judge